Well, good afternoon, everybody. The hush tells me it is time to get started. So let me welcome you to the Law School's Martin Luther King Day programming. I have to say I am truly delighted to see everyone here who believes that while this is a federal holiday, it's a federal holiday for a purpose. And we're trying to use this afternoon to remind all of us of that purpose. I have to say, when I've looked at our panelists, I first of all want to thank the MLK Day Committee for putting together this fabulous afternoon. And we're truly in, I believe, for an intellectual treat. But while I'm proud to say this, I also have to admit that I'm quite sad that I have to say that. And that is especially true for the first panel. More than 45 years after Dr. King's death, we should not still have to have a panel in which we need to discuss the criminal justice system as a challenge to justice, as a locus of racial inequality, and as a prime example of unfairness in our legal system. When you think of the death penalty, our prison population, those under supervision of the correction system outside of prisons, our collateral sanctions, everything falls unequally upon certain members of our society. So what we see is that every aspect of the post-conviction system really reflects in the starkest terms the inequality with which we live daily. Now perhaps what might be most disturbing is the fact that there are so many who are totally untouched by that part in our society. That they lack direct contact with those certainly under supervision of the correctional system, but also with their families and communities. And in that way, we truly have two societies in one. Now, let me just add one thing. Since I do care personally very much about sentencing and corrections. The concept that we could just impose very long prison sentences on high-status white-collar defendants is not a solution to racial inequality. All it does is reinforces the penalty, the punitiveness of our criminal justice system, but it's certainly not a solution to the underlying racial inequality that we have in our system. Now, our second panel this afternoon takes on the issue of immigration, a matter that has often now been called the new civil rights struggle. I'd argue that we're still in the midst of the first civil rights struggle, but certainly immigration has become a hot-button issue in Congress and around the country. We're struggling collectively with the question of what to do with millions of undocumented immigrants, most of whom have made a permanent life in the United States, many of whom have children who are citizens of this country. Now, as with sentencing, the ramifications are not only for those directly involved in the world of immigration, but also for their families, their communities, and their employers. And it is truly important, I think, for all of us as a society that we find a fair and equitable solution. Last, but certainly not least, later this afternoon, we will hear from our keynote speaker, Harvard Law School professor Kenneth Mack. Professor Mack is a nationally known authority on the constitutional and legal history of race relations in this country. And he has also written not only on this relationship, but also on the concept of the civil rights lawyer in our society. Professor Victoria Shannon will introduce Professor Mack later this afternoon. So I think you will agree with me that what we can look forward to is a challenging, perhaps sometimes disturbing, but I'm convinced always engaging conversation this afternoon. So welcome to all of you, and especially to Professor John Shapiro, who will moderate the first panel.
Thank you, Dean. And I want to welcome you to our first of several events at the law school celebrating the birth and work of Martin Luther King. Our first event is entitled Sentencing and Race, and we are so lucky to have with us three people who have devoted their professional and personal lives to shedding light on and battling and changing the way this country does justice to its minority citizens. Indulge me while I make this point. You who are law students here today, you are some of the luckiest people on the face of the earth, with the exception of those who may have had to sit through some of my classes to decide. But it is true. Do you grasp how privileged you are to be at this institution, to be on the verge of becoming lawyers, and to have the incredible power that a license to practice law brings with it? I remember being in the 10th grade when Dr. King led the March on Washington. And I was set to take a bus from Cranford, New Jersey to Washington, D.C. The day before the event to meet my aunt and to join the march. I got up the day before and I was sick as a dog, and I didn't leave my bed for 2 days. And instead I watched everything on TV. And to this day, I remember the thrill running through me, watching people say the things that needed to be said, doing the things that needed to be done, not afraid to stand up. These things could and did change the world. Well, some years later, I managed to trick a law school into letting me attend, and I found my own humble way to, not to change the world, but at least to fight for folks who couldn't speak for themselves. And so my point in telling you all this and about how privileged you are, Dr. King had his pulpit. You may have a podium in a courtroom someday, or a seat in a boardroom somewhere, or a lectern at a law school. You have been taken in here into this great law school and will be given this incredible power. Don't blow it. All right? A law license is not a license to make money. It is not a pass to a cushy life. It is an obligation to do for others who weren't given the privilege you were. And that brings us around to our speakers today, and who, as a concession to the shortness of life, I will do an injustice by summarizing their professional lives in the most inadequate way. They are, of course, Michael Nachmanoff, Professor Wornie Reed, and Professor Margareth Etienne. I will introduce each before they make their comments. I'm going to start with Michael Nachmanoff. Let me tell you a little bit about Mike. Since 2007, I believe, he has been the federal public defender for the Eastern District of Virginia. Prior to that, he was the acting federal public defender, and prior to that, he was the first assistant public defender. And I mean first in both sense of the word. He was the second in command at that office, and he helped start that office. And it is a powerhouse of an office, largely due to Michael's influence. If they don't have 5,000 lawyers in that office, they sure as hell litigate with the power of 5,000 lawyers, in my view. It's the 7th largest PD's office in the nation, federal public defender. It's got offices in Alexandria, Richmond, Norfolk, Newport News. And I got to tell you, running that office is not a walk in the park. The Eastern District of Virginia is where the government chooses to bring every case that it must win. And it's Michael's job to see that it's a fair fight, something he's done with great success over the years. And I'm talking about cases like Massawi and the Somali pirates cases, you name it. Probably as a result of his success there, they have now kicked him upstairs. He's been selected to serve as our next United States Magistrate judge. Congratulations to you for that. As public defender, Michael has testified before Congress multiple times, not as a defendant. This included during the sequestration crisis, and it was his powerful fight for adequate funds to defend the poor that largely ended that crisis for the federal public defenders. He's been a forceful advocate there for the overhaul of discriminatory sentencing laws. Michael was an honors grad at Wesleyan. He graduated from law school in Charlottesville. And aside from this, and is highly pertinent to today's proceedings, he argued and won one of the most important sentencing cases at the United States Supreme Court, Kimbrough, having to do with the infamous crack powder cocaine sentencing disparity. And that case is one which cemented the authority of federal judges to impose just sentences. The measure of this man is what he would name as his 3 best accomplishments. Performing guitar with the legendary Al Stewart, a hole-in-one on a 165-yard par 3 blind tee shot. I don't even know what that is. And most important, raising 3 daughters. Thank you for being here with us today.
Thank you for that introduction. I cannot possibly do it justice now. It is such a pleasure and an honor for me to be here and to speak to you today and to share the panel with 2 such distinguished fellow speakers. And let me just say, by way of disclaimer, that I am in no way an academic, unlike my extremely well-credentialed fellow panelists. And so what I think I can share with you is my experience practicing law and my experience with race and sentencing in the federal courts. And I'm, like you, equally fascinated to hear what the others on the panel have to say. And I hope that I can contribute something that's of value to you as we think about Martin Luther King's legacy today and all that we have to do for ourselves and for this country. Let me just say briefly, before I start talking about the federal system, as probably many of you know, in this country we have almost 2.5 million people incarcerated. Now, the vast majority of those people are incarcerated at the state level. And that's not an area that I'm going to talk about today. It's an extremely important area, and it's the overwhelming majority of those folks. There are about 215 or 220,000 people in the Bureau of Prisons, the federal system. The United States represents 5% of the world's population, but the United States incarcerates 25% of the world's incarcerated population. That is a stunning, stunning fact, and I'm terrible with PowerPoints and I don't have one, but if I showed you a graph of the number of people incarcerated in this country compared to every other country in the world, both westernized, first world, democratic countries and totalitarian governments, you would be amazed to see that the United States is #1 without a close second. That also has an impact on race. African American people are 6 times more likely to be incarcerated than whites. Hispanics, Latinos, 3 times greater. Both of those groups together make up 60% of the total prison population. That's the bad news. What I wanted to do, though, is focus actually on what I think is good news. And as I thought about Martin Luther King and the wonderful orator that he was, there was a quote of his that I'm sure many of you are familiar with that made me think about my experience in the federal criminal justice system, and that is, the arc of the moral universe is long, but it bends towards justice. And I believe that that is true. And I think that my experience of 20 years in the criminal justice system shows that it is true, both that it is long, but that it bends towards justice. And I guess the only thing that I would add, and I'm glad that Dr. Martin Luther King didn't add it, is that it bends slowly towards justice. And so I think that I can say, as I look back, and this is what I'm going to talk about for the next few minutes, that there's been tremendous change at the federal level. And there's change that gives us good reason for hope for the future. But we have a long way to go as that arc bends towards justice. So just to take a few minutes to talk about this, I want to talk about what I think is the lowest point in modern federal sentencing history. And I don't want to give a long lecture, but the big picture is that we had an indeterminate sentencing scheme all the way up until the Sentencing Reform Act. Many of you, I'm sure, know this in great detail. And in 1984, Congress passed what they thought was going to be, to some degree, a progressive legislation that would make the system fair. And it was a bipartisan effort that was supported, and it was a more than a decade-long effort on the part of both Democrats and Republicans, both strong proponents of reform because they were concerned about the variations in sentencing where judges had really unfettered discretion to impose sentences that could be influenced for all the wrong reasons. For example, the black bank robber in Alabama getting 20 years by a federal judge, and the white bank robber committing a similar crime in Boston getting 5. Those were the kinds of things that motivated those who wanted to see discretion controlled or cabined on the parts of judges. On the other hand, there were those in the law enforcement community or on the right who supported reform because they wanted to see sentences increased. They thought that punishments should be increased. And the result of the Sentencing Reform Act certainly did achieve that goal, which was to dramatically increase sentences. No more was this more pointed than in the crack and powder sentencing debates that went on for about 20 years. And John was very kind to allude to the small role that I played in it. But that was a role that ultimately resulted in the Kimbrough decision of the Supreme Court that was really almost 20 years in the making. Again, for those of you who may not be familiar with it, in 1986, Congress passed the Anti-Drug Abuse Act, which set the penalties for crack at 100 times greater than the penalty for powder based on quantity. In other words, if you had the equivalent of a packet of sugar, like you would put in your coffee, 5 grams of crack would be 5 packets of sugar, you would be subject to a 5-year mandatory minimum. It took 500 grams of powder cocaine to get that 5-year mandatory minimum, so half a kilo. So you could see that there was a tremendous difference in that punishment. And what that meant was that people who trafficked in crack, even very small amounts of crack, were subject to much more severe penalties than those who trafficked in powder. Now, what we know today, which was understood, but perhaps less so at the time that Congress passed these laws, is that crack and powder are pharmacologically identical substances. Powder is one of the ingredients for crack. Crack is simply made by baking powder with baking soda and water, heating it, and then it can be ingested in a different substance. This is the only area of the law in which a drug was punished differently based on the method of ingestion. It would be similar in some ways to the idea that if you got drunk and crashed your car, you would be punished more harshly for having drunk whiskey rather than beer. But at the time that these laws were passed, there was, to a certain degree, a belief that crack was more addictive, that it was more associated with violence, that the properties of crack being ingested by a mother would have a deleterious effect on the fetus. It didn't take very long for scientists to understand that all of that was incorrect. That, in fact, the greatest way in which cocaine is addictive is through injection, not through smoking it, and that the effect of other drugs is much more harmful on a baby in utero than either crack or powder, the most severe, of course, being alcohol. Unfortunately, the punishments for crack and powder were codified by the Sentencing Commission, which was created as part of the Sentencing Reform Act, in a way that punished crack far more severely than powder. And so what we saw in the 1990s was a generation of young, overwhelmingly African-American young men being sent to jail for enormous lengths of time. And starting in 1995, so only a few years after these laws came into effect, the Sentencing Commission began issuing reports repudiating what they themselves had done, which was to impose far more severe penalties for the lowest level traffickers, those who could be caught on the streets dealing retail amounts of crack cocaine, as opposed to wholesale managers and kingpins who provided the raw materials to make crack. And despite the Sentencing Commission issuing ultimately 4 reports in 1995, 97, 2002, 2007, we had what I believe was the most corrosive and pernicious aspect of the federal criminal justice system, in which people who were subjected to these punishments and their family members and their communities perceived that the criminal justice system was terribly, terribly unfair, and that it was terribly unfair in a grossly racially disparate manner. That was particularly true in the Eastern District of Virginia. Not very far from here, we're in the Western District, but if you just go a few miles down the road, you'd be in the Eastern District, which had the dubious distinction of having the largest number of crack cases in the country. And you have to ask yourself for a minute why that would be. The Eastern District of Virginia is comprised of Northern Virginia, which is the suburbs of Washington, D.C., Richmond, which, while a city in the capital of Virginia, is not nearly as large a city as New York or Miami or Chicago or Los Angeles, and Tidewater, which is a sprawling combination of suburban and urban and rural areas. This was a reflection of the priorities of the Department of Justice. The Department of Justice focused on crack cocaine. They focused on it at a very low level. The Eastern District of Virginia had the largest number of cases involving crack cocaine involving less than 35 grams, less than something you could hold in your hand. And we had people who went to jail for decades for these crimes. In 2006, the Supreme Court declared that the sentencing guidelines were unconstitutional in their mandatory form. And again, I don't want to take up too much time because we have the other panelists, but this was the beginning of a really dramatic change for those of us who had practiced in a system which required judges essentially to be bean counters, to look at the sentencing guidelines, to count up the criminal history score, to look at the offense levels, and then impose a sentence. And for years, and John, while he's very complimentary of me, you should know, if you don't already, is one of the finest and most highly respected criminal defense attorneys in Virginia. John represented many of those people, as did I, in which judges would impose sentences of 10 years or 20 years, or sometimes mandatory life, depending on their criminal histories. And the judges would often say, this is an unjust sentence. I don't want to impose it, but the law requires me to do so. They would say, my hands are tied. Well, in 2006, when Booker was decided, all of a sudden judges, once again, have the responsibility, to some degree, in imposing the sentences. And there was a brave judge in Norfolk, Judge Ray Jackson, who decided that he was going to take into account what many people across the political spectrum have been saying for years, including the Sentencing Commission, which is that there is no justification for the disparate sentence between crack and powder. We had a client who was convicted of distributing 54 grams of crack cocaine. He was subject to a 10-year mandatory minimum. He also had a gun. He had a 5-year mandatory minimum for that. And Judge Jackson concluded that 15 years was enough. But the guidelines came out to more than 19 years. And amazingly, after he imposed that sentence, post-Booker, having the authority to do so, the government thought that it was so important that this young man, who had been a veteran, who had relatively little other criminal history, who had committed no violent acts, that it was so important to vindicate the principle that Judge Jackson should not impose a sentence of 15 years, that they appealed that sentence. And the Fourth Circuit reversed it. And virtually every circuit agreed with the Fourth Circuit that because Congress had decided on this 100-to-1 ratio that it would be inappropriate for the courts to take that into consideration. Although Joan was very generous, and I was lucky enough to argue that case, our victory in that case was the product of the work of federal defenders and other criminal defense attorneys for years, which had put us in the position of arguing that now that judges had this discretion again, they absolutely could and should be able to take into account the unwarranted disparity between crack and powder cocaine. And the Supreme Court agreed, along with a series of other cases, which really was not so much about race, in my view, as it was the relative power of judges. The Supreme Court clearly believed that trial courts, the people who actually look at a defendant in the eye, as opposed to appellate judges who read a transcript and sit in a library, that trial judges should be the primary deciders of what a sentence should be. And therefore, that unlike the 20 years of the mandatory guideline regime, that appellate courts should really defer to trial courts when they decide to take a particular fact into account. In this case, the disparate impact of crack and powder in drug sentencing. So this was a small move towards a more just system. And at the same time, the Sentencing Commission recognized that the penalties that they themselves had put in place 20 years earlier needed to be changed. And they voted internally to reduce the levels for crack cocaine. We had a process that some of you may be familiar with called crack retroactivity, in which we went back and we looked at our prior clients and we looked at the clients of other people, including John's clients, and John did some of those cases himself. And in the end, we were able to get sentences lowered nationwide for more than 15 or 16,000 people. People who had often served 8, 10, 15 years of sentences that would have gone on much longer. And so, again, as the arc of the moral universe may be long, it can bend toward justice. And we saw that by getting these people released and returned to their families 2 years, 4 years, 10 years earlier than they would have, the sky didn't fall. Opponents of that process said, well, you're going to have people running around committing crimes left and right. And what we see now 5 years later is that the recidivism rate for people who were released early not only is not higher than the general population, but to some degree it's a little bit lower. I like to believe it's because for the first time, somebody in the criminal justice system actually did something to help them in a system that they quite rightly thought was terribly unfair. Amazingly, in 2010, after Kimbrough and after the first round of crack retroactivity, Congress, for the first time in the modern era, voted to reduce mandatory minimums in crack cases. So the Fair Sentencing Act was passed in 2010, which reduced the ratio from 100-to-1 to 18-to-1. This is not where it should be. It is not what proponents of reform wanted. It was a political compromise. But it made a huge difference. It reduced dramatically those sentences. That decision was made retroactive by the Sentencing Commission, and we went around again and reduced sentences again for people who are still sitting in prison for these crack sentences. These were individualized motions. This was not done without review, without understanding how these people had behaved in prison, what their plans were for the future. But federal defenders and others, but primarily federal defenders, worked very hard to reduce sentences. Well, since that time, and again, I don't want to take more time than I've got. There's plenty to talk about. We're going through yet a third round of retroactivity because the arguments with regard to punishments for crack and powder apply to some degree with equal force to many other drugs. And so the Commission has now realized that rather than being a one-way upward ratchet, that the punishment for drug trafficking is too severe. And so now people who have been convicted not just of crack, but of powder cocaine offenses and other drugs are subject to retroactivity once again. And we anticipate we will help thousands of people in the coming year to get their sentences reduced and get out. So although we have a long way to go as we think about Martin Luther King on this day, there are many reasons to be helpful. For the first time in Congress, people are talking about rolling back mandatory minimums, not just in the context of crack, but through the Smartest Sentencing Act for a wide range of mandatory minimum cases. There's the Redeem Act, which is being proposed on a bipartisan level by Cory Booker and Rand Paul, which would restore certain civil rights to those convicted of felonies and put under seal nonviolent convictions, which can prevent people from getting jobs. These are discussions that 5 years ago, 10 years ago would have been political suicide. And now we have people on both sides of the political spectrum interested in finding ways to reduce the prison population, to address, to some degree, issues of racial disparity, but certainly recognizing that our criminal justice system is an area in desperate need of reform. And so slowly, the arc of the moral universe bends towards justice. Thank you.
Thanks. Now, let me introduce to you Wornie Reed, who I had the privilege of just meeting today, and I am glad I did. Professor Reed is a professor of sociology and Africana studies at Virginia Tech, right down the road. He is also the director of the Race and Social Policy Center at Tech. Among other things, the center conducts original research in the area of public policy with an emphasis on race and ethnicity. Before Tech, Wornie was a professor of Africana Studies and the director of the Africana Studies program at the University of Tennessee in Knoxville. A primary interest of his is, unsurprisingly, race and criminal justice, and also health and race as it affects criminal justice, including the exploding and remarkable issue in criminal law circles of lead poisoning and its role in violent crime. Professor Reed is the author of many books, including the 2011 book, Racial Profiling, Causes and Consequences. He's a graduate of Alabama University, got his master's and his PhD from Boston University. And aside from teaching at Tech, he has taught at the University of Tennessee, at Cleveland State, Morgan State, at Washington University. At Cleveland State, he was a professor of urban studies, and for 10 years, if I have this right, the director of the Urban Child Research Center at Cleveland State. Basically, he's another one of these guys who just can't seem to keep a job, apparently. Or he has cloned himself to be able to do more than what a mortal can possibly do. He serves or has served on or been the chair of or the director or the founder of more boards and organizations than you can shake a stick at, many dealing with issues of race and health, many dealing with issues of the welfare of children and preventing youth violence, and many dealing with the issue of minority incarceration. He's authored scores of chapters in books on race and health and found time to win 2 regional Emmys for his work with public health television. It's a pleasure beyond description to have him here with us today.
Thank you very much for those kind words. They were really too kind, because he made me, on the one hand, my age, but also he made me younger than I am. When I went to undergraduate school, I could not have gone to the University of Alabama. I went to Alabama State, historically black school in Montgomery, Alabama. And I might as well have admitted that to you, because you would have started calculating something about how long I've been around when I tell you that I participated. Unlike John, I managed to make it to the 1963 March on Washington. And I participated in a number of events that Martin Luther King led, including the Poor People's Campaign, which was his major emphasis, whether you know it or not, at the time of his death. The Memphis garbage strikers work was kind of a side trip, and he was involved in many things. But the major thing was the Poor People's Campaign, where he was intending to enlist everybody who would join him in calling attention to this issue by occupying D.C. Now, it may surprise some of you. I didn't plan to say this when I stood up, but here's what he said. We will beseech our government to do something about poverty in the country. And we will go to Washington and we'll stay until they do. And if necessary, we will close it down. And that's new to some of you. And I better stop there. I'm going to be giving a talk next week about reclaiming the Martin Luther King I knew. Because the one we celebrate a lot around the country today is an imposter. He's not the person I knew, but that's not what I'm supposed to be talking about today. What I'm going to talk about today is to talk about something, some reason why we need to reclaim him. Because if we were to reclaim him the way he did things, we would address these issues. So I don't have anything else good to say. Everything from now on is going to be bad. And so therefore you'll be glad when I finish. Let me see. I need to... Okay. I'm going to talk about race and sentencing in juvenile courts. Now, they don't use that term sentencing in juvenile courts, but I'm going to use it with you because you may be more familiar with that term. They call it final disposition, the outcomes. They just don't like to use these adult terms in juvenile justice. So what I want to show you now is the way that this was looked at a long time ago. You had legal variables. These are the things that were supposed to determine whether or not you were sentenced or whether or not you were put in some confined place. So one of these is the prior record. That is, how many times have you been referred to court, or to the juvenile court? What's going on here? Okay, well, we've got to get this better, I guess. Things are going backwards for me. Okay, now, the next one is offense type. I'm sitting the left side. And those are the two legal variables that should count the most for determining whether or not a youth is going to be, I'm going to call it, incarcerated. They don't use that term in juvenile courts. However, 30, 40 years ago, we would look at extra legal variables as well. These are social variables like race and gender. So this is the way things were done before. We would look at this, but what happened is some of us were involved in the early 1980s in looking at some other things that affected whether or not a juvenile is incarcerated. That is, I'm just going to jump to the bottom line. And one of these was detention, the detention decision. There are some process variables, some process points in the juvenile court that have a lot to do with what happens later in the proceedings. One of them is the detention decision. The detention decision is whether or not a youth is held in a pre-adjudicatory phase of the process. I'm using one of your terms. The next one is the screening decision. The screening decision really means the manner of handling. How is the youth handled? Is it formal or is it informal? Well, that makes a lot of difference, because if it's handled informally, then this person cannot be sentenced to secure detention as an outcome. And so these are the process variables. So a colleague and I added this to the literature of what we should be looking at in addressing the issue of whether or not there are racial disparities in juvenile courts. And so this is the conceptual framework that we introduced back in the 1980s. that we look at those legal variables, we look at those social variables, but we also look at detention decision, screening decision, and final disposition. So when we looked at this data, we found that whether or not a youth is detained before there's a hearing determines to a substantial degree whether or not the screening decision is going to be formal or informal. Oh, and I might tell you that we were analyzing data from across the country, from some 12 states and major jurisdictions that had begun to submit their data to the Office of Juvenile Justice and Delinquency Prevention in the Department of Justice. The screening decision, that is the manner of handling, determines to a large extent, sometimes, but sometimes not, the final disposition. So these are the kind of things we were finding. We found that blacks had much more pre-adjudicatory detention. That is, black youth were held before a hearing overnight in secure detention much more often than white youth. Blacks tended to be handled formally. In the screening decision, it would be a formal process, which meant, if you're familiar with the juvenile courts, that there would be a petition filed. And of course, what we were all looking at during that time and ever since is whether or not African American youth received more, proportionately more severe dispositions. And the key one that you would look at is whether or not they got secure detention in a youth facility. So recently, we've applied this model to Tennessee. So I just jumped in those few seconds 30 years. So in the 1980s, we found what I just showed you in the previous chart. So now, what we find now in Tennessee, looking at the year 2006, where we looked at all cases of youth appearing before juvenile court in Tennessee, over 132,000 cases. Same thing. Blacks were detained 3 times the rates of whites in the pre-adjudicatory process. That is, before any hearing. Saying, well, this youth we should not let back on the street. Let's hold them until we decide what to do. That is, to have a hearing and what we would call for adults a trial. Blacks, in 2006, in Tennessee, were handled formally 17% more often than whites. What that meant is that there was a trial, a hearing, a formal hearing for juveniles in the juvenile court, 17% more often for blacks than for whites. Remember now, if you're handled informally, you cannot be sentenced to a juvenile facility. So whites were handled informally more often, 2006. And of course, blacks received more severe dispositions. That is, they were sentenced to secure detention more often, 20% more often. We're just beginning to look at Virginia data. So I don't have the same level of analysis there, but I do have analysis from the group data. Just to show you what, and I would like to ask you, what do you expect our data to show after I show you this chart? Okay. Don't try to read all the numbers. I'll just look at the third line, cases involving secure detention. That is detention before a hearing. What that line says is that black youth in Virginia in the year 2010 were 80% more likely to be held in secure detention before a hearing. Okay. Remember now, if you're held in secure detention before a hearing, then you're more likely to get a severe disposition. And in Tennessee, cases diverted, where those that get diverted are brought to the court and diverted before the detention decision is made. Blacks are 10% less likely to be diverted from court. And we have the same data, cases resulting in delinquent findings. That's juvenile talk for kids found guilty and who are put in secure detention. They're 20% more likely. The same data we found for Tennessee in 2006. 20%, blacks are 20% more likely to be sentenced to prison. And the bottom line, cases resulting in probation placement. Blacks are 10% less in 2010 in Virginia to get probation. That is, the final disposition is to give them probation rather than put them in a facility or something else. So, what do we conclude from this? I just have a couple ones, and you may have others. One, racial differentials in juvenile court processing has continued through the decades. Despite all of this talk about things getting better, they're not. In fact, in the criminal justice system, I've argued it's getting worse, but in the juvenile system, the certainly is not getting any better. And it raises a question about the viability or the continued viability of juvenile courts having discretion. Discretion has always been, as I understand it, an aspect of the juvenile court, where some things are left up to the discretion of the officials, the judges and the others, rather than abiding by any strict law. Because they said these people will know better what to do with you. It seems as if we have the same conclusion nowadays that we had back in the 80s and that we proposed, is that the issue of discretion be looked at and examine, is this something that should continue? I'm not sure. I kind of side with the fact that it should probably not be continued unless there's some very good arguments for continuing, and we can find some other ways to reduce this disparity, this racial disparity in juvenile courts. Thank you.
Thank you, Wornie. Okay. Our final speaker on this panel, Margareth, Etienne, who I also had the pleasure of meeting for the very first time today. Again, I'm glad I had that opportunity. Back with us, having spoken at WNL some years ago. Professor Etienne is a graduate of Yale, twice, undergraduate with honors, and Yale Law in 1995. She's now a professor of law at the University of Illinois College of Law, where she teaches criminal law, criminal procedure, children in the law, sentencing law, and policy. You could fairly well predict where this woman was headed early on in life, even before graduating law school, if I have this right. She taught French at a rural Mississippi high school. She worked with the Yale Haitian Refugee Committee to secure release of refugees from Guantanamo, Cuba. She worked at the Center for Constitutional Rights, helping to train lawyers in international human rights lawsuits concerning torture. She worked at the U.S. Department of Justice on issues of environmental law and prosecution of white-collar crime. This is all before law school ended, I think. After law school, she served as clerk to the Honorable Diana Motz on the Fourth Circuit Court of Appeals. You know, I have lost so many cases in the Fourth Circuit that I had to go back and check. How many were before Judge Motz? And was there ever one there when Professor Etienne served? And indeed, in 1995, I lost a case called United States versus Ishmael. You remember it? Thank you so much. All is forgiven. After her service on the Fourth Circuit, she was at the University of Georgia, supervising students in a criminal justice clinic, and then in Atlanta, where she was a federal public defender for 5 years, handling every sort of criminal case you can imagine, I'm sure. She's written extensively on sentencing issues, and in particular the issue of race and sentencing, which brings us together today. Professor Etienne, thank you.
Thank you. A little bit embarrassing, but yes. I'm really happy to be here today. And I've learned already so much from my esteemed sort of colleagues on this panel. So today we're celebrating Martin Luther King, Jr., and so I want to make some comments that relate, obviously, to that celebration, but also recognizing the sort of depressing, sometimes, topic that we have before us. Just as orange is the new black, just as mass incarceration or criminal justice rights is the new Jim Crow, criminal justice is often thought as the new civil rights movement. Indeed, it's not uncommon to turn to analogies to make sense of current events and problems. Overcriminalization, we've heard about the prison industrial complex, the school-to-prison pipeline, the ban the box movement, have all been decried as venues in this new criminal justice / civil rights movement. So we've seen marches and demonstrations and die-ins all taking place around the country, large and small, on our college campuses much like this, and in our public squares and spaces. So as we think about this new civil rights movement, what we can call perhaps the criminal justice rights movement, and as we celebrate Dr. Martin Luther King, Jr. today, it's not hard to also think about some of the tools of King's movement. The celebration of Dr. King is the vindication, in some sense, of nonviolence or pacifism, and I know that it's only sort of one version of the King that we see talked about mostly today. But when we think about Dr. King and the celebration of nonviolence, at least in part, or pacifism, at least in part, we can think about pacifism both as a strategy, and it makes me think about what are the strategies we might want to use today. If we analogize criminal justice movements to the civil rights movement, how might we analogize the tools of the civil rights movement to the tools we might want to use today? Is there something we can learn from that? So as I started to think about this, and think about the strategy of pacifism in the 1960s, and what a modern version or analogy might be in the context of sentencing and criminal justice today. What are our strategies? So let's start with pacifism. And how does it work? And how might some analogy, some version of it work for us today? So when I think about nonviolence, or I think about pacifism, generally speaking, it's a rejection of the use of violence or physical force to attain a political end or a social end, a social goal. But why does it work? Does it work? Some pacifists believe in nonviolence, right, as a matter of morality. That is to say, it's simply wrong to harm others. Period. Full stop. End of story. It's just wrong. This kind of pacifism isn't necessarily designed to do anything, right? That is to say, it's not consequential in nature. It's not meant as a tool, per se. But some pacifists uphold nonviolence precisely because they believe it is a tool, right? Because it has net positive consequences to be nonviolence, or rather that violence itself has net negative consequences. So was Martin Luther King a moral pacifist? So perhaps a deontological pacifist? Or was Martin Luther King a strategic pacifist, right? And I hadn't seen the movie Selma when I first started writing, preparing for this, and I think the movie speaks a little bit to sort of the strategies that are used in thinking about nonviolence as a strategy. And I'd like to say maybe both, right? That there are lots of Dr. Martin Luther Kings out there, in part, and there is sort of moralists, but there's also the strategists. And I don't profess to be as moral a person as Dr. King, so I've really been more interested in the strategist part of it, right? I've been particularly interested in thinking about the strategy for social change and how that might apply to criminal justice. So, but let's talk a little bit about the strategy of nonviolence, or the strategy of social change in this context. So according to King, nonviolence worked in a very specific way. So I think about a document that he wrote that reveals his approach. And in a speech, he explained, and I quote here, that there are 4 tenets to using what he called the methods of nonviolence successfully. According to King, for this strategy to succeed, you needed these 4 things. 1, nonviolent demonstrators go to the streets to exercise their constitutional rights. 2, racists resist by unleashing violence against them. 3, Americans of conscience, in the name of decency, demand federal intervention and legislation. And 4, the administration, under mass pressure, initiates measures of immediate intervention and remedial legislation. Right? And then there's a cycle, right? So you repeat these 4 steps. I want to focus on step 3 today because I think it seems to me to be the critical step that warrants consideration when we think about criminal justice. So I'll repeat it. Step 3. Americans of conscience, in the name of decency, demand federal intervention and legislation. In other words, nonviolence worked in the civil rights movement because it relied on the notion that atrocities suffered by African American men, women, and children would be impossible to bear by the average American. That when African American protesters were being mauled by dogs, beaten by police, harassed and spit upon by neighbors, when children carrying school books are being harassed by grown men and women, or churches were being burned, or young men were being hanged, that these sights, he thought, would be too difficult for well-meaning, conscientious Americans to witness. So the strategy, you see, relied on the assumption of empathy. And this brings us to wonder whether such a strategy, one based on empathy, could be successful in the context of criminal justice and sentencing. And I have to say I have my doubts. I have my doubts for 2 reasons. The first reason is obvious, and one that every defense attorney on the front lines knows well. Empathy is reserved for the innocent. We saw this in the Trayvon Martin case and Zimmerman trial, right? It was easy for one side to try to portray Trayvon Martin as being really violent, right? As being deserving of the response that he got from Zimmerman of being killed. And it was seen as a real atrocity by people on both sides, in part because he was just a kid. He was a teenager. He was going to the store to buy candy, right? Because he was innocent. And it is difficult because it evades the question of whether anyone deserves this treatment, guilty or not, innocent or not. We saw this in Ferguson, Missouri, right, where the victim at some point was being portrayed as a criminal, a robber, a thug, as if to say that had he been or if he was a robber, a thug, a criminal, that he would be deserving of the treatment that he got. But the strategy works, right? Because even when we do our die-ins and our marches and our demonstrations, we do so in part on behalf of those we perceive to be innocent. So the second reason, well, I'll say that empathy is critical to reform in criminal justice, but there's not much empathy in the criminal justice system. And the second reason I doubt that it'll work deals with an article that I wrote a number of years ago entitled Pain and Race. Pain and Race, a New Understanding of Race-Based Sentencing Disparities. And in that article, I identified a similar problem. I argued that there was a certain desensitization to the pain of people of color in our criminal courts. And what was a little bit different about this piece, I'd say, is that it moved away from the traditional debate about whether racism is intentional or unintentional in the criminal justice system. I think many of us who've practiced in courts would be quick to say that, not in every case, but a lot of the judges, a lot of the prosecutors, a lot of the people that we dealt with often were well-meaning in intent. And to attack their behavior, their conduct, the results of those cases based on intentional racism is a losing strategy. So it's something that goes beyond the debate of whether this was intentional racism or non-intentional racism. I focused in this paper instead on how research in the field of medicine and public health have been considering pain treatment for a very long time, literal pain, right? How doctors treat pain among racial and ethnic minorities in hospitals and healthcare practitioners. And the thesis was simple. One that I didn't invent, but that psychologists and other social scientists were realizing that individuals have different capacities for perceiving pain and identifying pain in others, particularly in others that don't look like them. In other words, pain empathy. Based on this research, a number of studies showed that people in one ethnic or racial group perceive the pain of those in other ethnic or racial groups differently than their own. And these studies revealed that pain is generally undertreated in our country, but it's particularly undertreated among people of color. So that the treatment of pain, particularly acute pain, among African Americans and Latinos were often undertreated compared to the same level of pain, the same nature of disease or condition. And that even when everything was held constant, ability to pay, health care, facility, even with basic things like the dispensation of aspirin, right? In the clinical setting, African Americans and Latinos were much less likely to be treated for their pain. There's one study that I want to mention to you really quickly. So there's a Duke University study where they've got 8 actors to act as patients, and they videotaped them, and they showed them to 720 physicians. And the physicians had to sort of decide what treatment would be appropriate. All the patients followed the same script in describing their chest pain, and the descriptions were identical. They were given comparable occupations, comparable insurance benefits. And the doctors were asked to determine whether the patients had a narrowing of the arteries that should be referred to a cardiologist for potential diagnostic treatment that would be life-saving in this case. And the physicians were far less likely to refer the black patients for potentially life-saving tests based on these same reports than they were to refer the white patients. And there are statistics that go on, and I won't go over here, but they mirror, in many ways, the statistics that we've already heard regarding race in the criminal justice system. In a number of studies, 74% of Latinos and only 57% of African Americans were offered basic pain treatment for something like a broken bone, right? You don't really need to be a physician to know that a broken bone would be painful, right? Healthcare workers, physicians, nurses who were trained to identify, treat pain treatment, found themselves less sensitive to the pain of others. So how can we be surprised, right, at a society's collective numbness to the pain of racial and ethnic minorities in the criminal justice system, when we see it mirrored in the healthcare system, where the training to treat pain is particularly acute. By now we know that African Americans and Latinos are overrepresented in the criminal justice system, both among adults and we know certainly among juveniles. And there are a number of groups and organizations that have continued to document over and over this consistent discrepancy. For African American males in their 30s, 1 in every 10 is in prison or jail. When you consider African American males in their 20s, 1 in every 3 is under the control of the criminal justice system. That is, if not in prison or jail, then under supervision, in parole, under parole supervision, for example. Now, as an aside, you compare this to the fact that 42% of white males in this country between the ages of 18 and 24, so obviously the numbers, the ages don't track exactly, are enrolled in college, right? We're clearly developing 2 very different tracks in the system. So African Americans at every stage of the criminal justice system, and I've got a lot more statistics that I won't go through here, but at every stage of the criminal justice system are treated disparately. Whether it's at screening, whether it's detention decisions, whether it's at sentencing, whether it's the likelihood of conviction. They're arrested at higher rates, charged at higher rates, convicted at higher rates, are more likely to receive prison time, even when factors like the nature of the offense, the criminal history of the defendant, and other offender characteristics and demographics are held constant. Now we know the disparity is greatest for drug offenses, right, as Mike was telling us about, but it exists for all crimes, even outside of drugs. And consider, for instance, when we think about discretion, the changes with the sentencing guidelines since Booker. It is after it is that judges were given more discretion. Once this federal sentencing, according to the U.S. Sentencing Commission report, at least one of them, on the continuing impact on sentencing post-Booker, it appears, and there's some debate about this, we were talking about this over lunch, right, that the racial gap, the divide between black and white defendants is increasing. Right, now the judges have more discretion. Now, sentences overall are decreasing, right? So I prefer to be in the world that we're in, with lower sentences, even though the gap may be wider. But the gap is growing. The gap is still there. Judges are far more able, it appears, to feel the pain of the white defendants and white victims, right, who appear before them. And there's gender discrimination there too, right? Judges, in fact, are more likely to feel the pain of women defendants than male defendants, right? Those who have it the hardest are the men, and the men of color in particular. So if we return, going back to the lesson of the civil rights movement, we must ask ourselves, how do we appeal to, quote, Americans of conscience in the name of decency? How do we appeal to that group of Americans and demand change or reform? How do we appeal to our better selves as Americans? Here's what we all in this room, I think, can do. Like on campuses everywhere, just as this one, there are demonstrations, and there are teach-ins, and there are die-ins, right? And John is exactly right, that we're privileged to be here. And we shouldn't blow it. But in these teach-ins, and in these die-ins, and in these demonstrations, right, things to protest the unarmed police shootings, for example, of people of color who are innocent, we also have to try to remember that justice applies not only to the innocent, but to everyone, right? That the great, it's great to work toward the innocent. But it's important, but that it's not enough, right? We have to get past innocence if we want to be a truly empathetic society. At least innocence as a prerequisite to being treated humanely. So to go full circle, I'll say this is where the other kind of pacifism comes in, right? This is where maybe part of the other Dr. King, or one of the many other Dr. Kings, come in, right? So we should sentence people humanely. And some people deserve to be sentenced, right? We should sentence them, but we should sentence them humanely, even when they have done wrong. Not for some consequentialist or strategic reason should we be humane, but because it's moral, because it's right. Full stop, end of story. Because it's the right thing to do. That's all I have.
We have time for one question. Whoever asks it, it better be a damn good question. Anyone? Yes, David.
So, and all of the presentations were fantastic, but I was sort of left with a question between the first and the second presentation, and I'd like, and I love remarks from everyone, but it's this question of discretion in the criminal justice system, right? It sort of stood out to me. We have on the one hand the evil of mandatory sentencing. On the other hand, we have all of the evils that emerge when we're allowed, when judges are allowed to just exercise full discretion. And so I guess I'm kind of left with the question, and I'm interested to hear the input of all of you. Is there a better way to be approaching this problem by sort of giving some mandatory guidelines to those that issue sentences, or giving them more discretion, or is that not even the right question to be asking right now?
No, I think it's a great question. I think it's the question that, in some ways, all three of these presentations are grappling with. I think in the federal system, I certainly won't speak about the juvenile system, except to make this one point, which I think is extremely important. Pretrial detention is an extremely important point in the way a criminal justice system operates. And the increase in pretrial detention, as Professor Reed was saying with juveniles, has an enormous impact on ultimately what happens, whether you're in the juvenile system or in the adult system. The rate of pretrial detention in the federal system has quintupled in the last 20 or 30 years. And of course, the rate for pretrial detention of people of color is much higher than that of whites. And there are a couple of reasons for that. The primary reason is that when criminal history becomes the primary driver of the way in which sentences are imposed, or the way in which the criminal justice system operates, it has a disproportionate impact on people of color, because people of color often are living in communities where they're more likely to be stopped, they're more likely to be arrested, they're more likely to end up with criminal history, which is why they end up serving more severe sentences that have recidivist enhancements, even though the actual criminal activity may be no greater than it is in other communities. The ability to arrest someone who's in public housing, or the ability to arrest someone where there's a greater police presence in an urban area as opposed to a suburban area, ends up having an impact on your ability to get bond. If you have a criminal history, you're less likely to get out on bond. If you're out on bond, you can demonstrate, even if you happen to be guilty, as ultimately in the federal system, 97% of people plead guilty, you have a much greater chance of avoiding incarceration if you've been out, because maybe you can keep a job, maybe you can demonstrate that you can pay money back if it's a property crime. So all of these things are related to each other. The issue of discretion is enormously important. You know, we have an adversarial system that comes from a British tradition, a common law system, in which you're supposed to have the crucible of cross-examination determine what happens in an outcome. Mandatory guidelines and mandatory sentences take that discretion away from the court and give it to one of the two adversarial processes. And this is the system that we've lived with. When you lock people up and then you ask them whether or not they want to plead guilty and get out the next day, or go to trial and maybe stay in jail the next 5 years, all of a sudden the calculus for making the decision as to exercise your rights changes. When you may face a 5-year mandatory minimum, or have a judge make an independent decision about your culpability and who you are as someone who's committed a crime and what the seriousness of the crime is, there's a big difference. So I have a very strong view on that. discretion is potentially a tool that can be used in improper ways. And historically, we know that judges are no different than everyone else. They bring their same cultural views, their same life experience, their same biases. You can never eliminate differentiation, regional differences, cultural differences. There are always going to be, to some degree, those influences in the imposition of the sentence. But when you have an adversarial system in which one of the advocates controls the outcome through pretrial detention and through determining sentences, you have the worst of all worlds. And I would argue very strongly that the shift towards discretion in the federal courts back towards judges is very good. Very good ultimately for people of color, and very good for a more healthy system. Because we still have mandatory minimums, because we still have enormous amounts of pretrial detention, and because we have a lot of judges who still abide by what are now advisory guidelines, we're not seeing the change that we'd like to see. But having that discretion move from prosecutors to judges is a much better, although certainly still imperfect, way of doing things.
I'm of two minds while proposing in the 1980s that we kind of think about getting rid of discretion in the juvenile courts. I was suddenly sympathetic in thinking that we should restore it to the federal courts. But I think there are two kinds of discretion here. Discretion in the I'll call it the federal and state courts, as I understand it, is kind of implicit. Discretion in the juvenile courts, ever since the reform of the late 1960s, has been explicit. So I just think that we might have something in between where there could be more kind of legal controls over the explicit discretion that's applied there, because it's applied without any kind of adversarial questioning. So I think we can have something in between. And I'm going to say that's what the law used to do.
I guess I just have a quick thought about that. I think that the judges have gotten a lot of attention in the last 20 years, and the question of judicial discretion has gotten a lot of attention. And it's an important question. But I think for the most part, judges are good and hardworking and do a relatively good job. Not perfect, by any means. I think that the legislatures have failed us. I think if I were to think about which branch of government involved in this system, somewhere between the executive and the legislatures, I think where we need to put maybe more attention, because, this notion of the prosecutors having almost carte blanche in so many ways in what should be an adversarial system doesn't work. And the notion that we have these mandatory minimums and we've got this 100-to-1 disparity in drug, in the sort of crack cocaine should never have existed. That's a major failure. We can't blame the judges for that. So I think that there are areas that we've spent for the last couple of decades really focusing on the judges. Not to say discretion is not an issue, but I would like to see us turn to really focusing on the failures of the legislators in all of this. And the weaknesses, maybe not failures, in the executive branch in all this. And I think that's a big distinction between the juvenile and the adult system, is the legislators have almost been silent in the juvenile system. And so that's where I think maybe there is more room to look consistently at the judges, because there aren't clear rules and laws, other than, when we don't like what's going on in juvenile court, we just transfer them to adult court. Right. But there's not a real system in place in the juvenile court on substantive issues. Procedural now, a little bit, yes, in the late 60s, but not so much on the substance of what should be happening in juvenile court.
You fulfilled my expectations. Thank you. Thank you all.